Good afternoon, everyone. Thank you for joining us for today's estate planning seminar. I would like to introduce the presenter for today's event, Heidi Klippel. Heidi Klippel is a San Diego native. She received a scholarship from the William Randolph Hearst Foundation to attend USD, where she graduated magna cum laude with a bachelor's in political science. Heidi was always a dedicated student and received various accolades for her scholastic achievements, including a feature on the National Dean's List, the Phi Theta Kappa Society International Scholastic Honor Award, and the Kappa Gamma Pi National Honor Society Award. Knowing she wanted to be an attorney, Heidi began working in law offices at the age of 14. After graduating from USD, she went on to obtain her Juris Doctorate from Cal Western School of Law, graduating in the top third of her class. During her time as a law student, Heidi concentrated her law studies in the areas of estate planning, tax planning, and corporate and business law. After completing law school and passing the bar exam, Heidi worked as an associate attorney for approximately 3 years before she decided to open the law offices of Heidi Klippel and has since been serving the San Diego community in areas of estate planning and corporate law ever since. Heidi's firm is located in La Jolla and offers comprehensive estate and trust services, including trust creation, trust administration, probate, conservatorship, and more. Thank you, Heidi, for joining us today.
Thank you so much for that introduction. Sorry, all of a sudden I got a frog in my throat, but my name is Heidi Klippel, and I am here in San Diego, been practicing estate planning law for almost 20 years now. I'm going to go ahead in the chat, write my phone number for anybody who might have questions after this presentation. I'm also going to put my email address here in case anybody has any questions that they'd like to email me privately. I know estate planning can bring up some pretty personal and emotional issues, so please know that if any of you have any questions after this presentation and would prefer contacting me privately, that is fine. So I've posted my phone number, I've posted my email. I also gave Suzanne a handout to send to the attendees of this presentation about estate planning. So if you, for whatever reason, did not get the handout, feel free to email me directly and I'd be happy to email that to you. So our presentation today is on estate planning. So my plan is to talk about some basic estate planning principles and then talk about some more sophisticated estate planning principle towards the end of this conversation. So for those of you who have an estate plan, I'll also talk about some changes in the law to make this presentation worth your time as well. So what I'd like to do first is just talk about the basics. So probably the most common question people will ask me is, what is an estate plan? And typically an estate plan is a revocable living trust, a durable power of attorney for financial affairs, a medical directive, and a special will that's used with a trust called a pour-over will. The next commonly asked question is, do I need an estate plan? And the answer to that is, all states have different laws, so everything that we're talking about during today's presentation is specific to California. So please know that if you did create an estate plan in the state of California, that estate plan is valid throughout the United States. But if it's written under the laws of our state, it will be interpreted under our state laws, regardless of the state where you might move. So if sometimes when people move from California, for example, to a neighboring state like Nevada or Arizona, a lot of our neighboring states are community states like California, so our laws tend to be pretty similar. But when you start moving to the Midwest and onto the New England coast, those are separate property states. So in those states, you don't do a marital trust between two spouses like you can do in California. In those states, you would have two separate trusts, one for each spouse. But in the state of California, you can do one trust for both spouses because we are a community property state. So having said that, I just want to explain that once you are a legal adult in California, which occurs at the age of 18, which I think is common for most states in the United States, one of the things that people should have that young people often don't have are their durable powers of attorney. And what a durable power of attorney does is it is a legal document so that if you lost your capacity, there's a durable power of attorney for financial affairs, and there's a separate durable power of attorney for medical affairs. So the benefit of having these two documents is if you were driving home from work and heaven forbid you were hit by a car, which is never planned, it's never expected, it's never convenient. The benefit of having these documents is the financial durable power of attorney identifies the people that you trust to make your financial decisions when you lack capacity and can't make those decisions for yourself. The medical directive is similar in concept, except it puts people in charge of making your medical decisions when you're not deemed capable of being able to make those decisions for yourself. So in our state, if you were sadly driving home and if you were hit by a car, drunk driver, and now you're in the hospital incapacitated in a coma, if you don't have these two documents in place, then the way a loved one, even a spouse, would have your legal permission to manage your contractual affairs and medical affairs is by petitioning the court to be appointed your conservator. So with Britney Spears being in the news recently, it's brought the whole conservatorship to the front light, not necessary in the best light, but what a conservatorship is it is a legal process where you petition the court to be appointed by the court to be a person's medical and or financial advocate when they lack capacity and can't do those things for themselves. The problem with our conservatorship process in the state of California, in my opinion, is the biggest problem, I think, is anytime you go through the courts, all those files and documents are public. So anybody can pull your file and see exactly what's going on with you, which when it comes to a situation like incapacity, you do oftentimes want to have some privacy. I did see that question. I'll get to that in just a second. The other problem with our conservatorship process is it's slow. On average, when I file a petition to start a conservatorship, the soonest I can get in front of a judge to start the process with that first hearing date is usually 1.5 to 2 months. So it's not a quick process. To be honest, nothing before the courts, with all due respect, is ever very quick, because in San Diego County, we have 3 sitting probate judges for our entire county, and by geographic area, we are a large county. So our 3 probate judges are hearing conservatorship matters, probate matters, guardianship matters, and trust administration matters, in addition to estate litigation matters. So our 3 probate judges have a lot on their plates, which means that they have a lot on their calendar. So whenever you go before our courts in the state of California, and I think all counties are pretty similar, I don't think San Diego is unique, because when I've appeared in Riverside courts and Los Angeles courts, the calendaring in those courts are usually 1.5 to 2 months, and sometimes even as long as 3 months out as well. So it's not unique to San Diego that our court process is a little slow. But when you file a petition to open a conservatorship, the filing fee alone just to file that petition is $425, which is a lot of money just to have a court stamp a document filed and to schedule a hearing date. And that's just a filing cost. So on average, our experience is a lot of times conservatorships can cost anywhere from $1,500 to $2,500, and sometimes more, depending on the complexity and the scope of the conservatorship. So in California, if I were hit by a drunk driver and if my husband and I were refinancing our house, even though we're legally married, he can't just sign my name on those loan documents, because signing a person's name on a loan document is the exercise of a contractual power. So in California, the way that you have those powers is through these durable powers of attorney or through the courts. So it's very important to have your durable power of attorney in place, partly because you also have the benefit when you create these documents of picking the people, family, and friends in your life that are financially astute, that you would trust to step into your shoes if you lack capacity and couldn't be your own financial advocate. So you have the benefit of picking who those people are. And generally speaking, you want to have a first choice, second choice, third choice, and fourth choice. You can have co-people acting in this role. So for example, if I wanted my brother and sister to be my co-durable power of attorney, I could have 2 people in place sharing that role. Personally, I'm not a big proponent of having people be because I find that when two people have to share a job, it tends to slow the process down because there needs to be a lot more communication between two people being on the same page and making decisions. Whereas if one person is at the helm of the ship, they can pretty much move forward and just execute and make decisions as they come out without having to run those decisions by a second person. But I do have people putting co-people in place. They sometimes think it shares and eases the burden by having two people in place to make those decisions. The reason you want to have at least 3 to 4 people in place is when you create these documents, it is important to mention that in these documents, the individuals named are being nominated. So under California law, if I were hit by a drunk driver and if I have my husband as my first choice durable power of attorney. So if he was about to leave the country hypothetically on a business trip and knew that he would be out of the country for 3 months, he could always decline that nomination and turn it over to the second person who's listed. So I do think it's important to mention that when you create these documents, nobody's legally bound to act or to be your advocate unless they agree to be that advocate. And the other thing that's important to mention in these documents is there is flexibility of resignation built into these documents. So if somebody who is acting needs to step down for any reason, they do have the ability through the documents to resign. There's also language in the documents that prohibits anybody who's nominated from being a financial or medical advocate if they lack capacity at the time of acceptance. So oftentimes when I do my estate planning meetings, I'll have people say to me, I'd really love my father to be my successor trustee, but he's 75 and in 40 years, he's probably not going to be a good choice. My response to that is when you create an estate plan, these documents and the language in them, they're legal language, and legal language actually does go stale, for lack of a better word, because the laws change, the tax laws change very often. So when you put an estate plan in place, what an amendable estate plan is or a revocable estate plan, it means it's a changeable estate plan. So as the people that you nominate in these documents, as their capacity might diminish, or if somebody passes away, or if there's a divorce, or if I've had clients find out that somebody that they named has a gambling problem or is filing bankruptcy. Not that there's anything wrong with any of those things, but now they're not so confident in the person's ability. One beautiful thing about an estate plan is because an estate plan is revocable, these documents are meant to be reviewed and they are meant to be updated. From a legal point of view, you want to update these documents about every 8 to 10 years just to make sure that the language doesn't go stale and that the tax language is current. That also gives you an opportunity to look at the people that you've nominated, because usually after about 8 to 10 years, it's not uncommon for people to change who they've named in these documents and or to change the order of people in these documents. And for people who have younger children or middle-aged children, it's not uncommon for you to name your children in these roles once they're of an age and maturity that you're comfortable with them making medical and or financial decisions. So that is what a durable power of attorney for financial affairs does. It puts a person in place to be your financial advocate if you lost capacity. And I do think it's important to acknowledge that between spouses, even if you are legally married in the state of California, you don't automatically have these powers. So if your spouse did become incapacitated, and if you were refinancing your house, or if it was time to file your tax return, the only way you can legally sign your spouse's name on a contractually binding document is by having their durable power of attorney giving you that contractual permission, or by petitioning our probate courts and being appointed that person's conservator. For medical decisions, you don't necessarily have to go through the conservatorship process to be appointed as a medical decision maker. Most hospitals and doctors' offices by default will always defer to a person's spouse to make medical decisions. But the tricky thing with that is sometimes you can have a disagreement between a spouse and extended family, like with Terry Schiavo. I don't know if you guys remember Terry Schiavo, probably 35 years ago out of Florida. She was in an accident. She was in a permanent vegetative state. Her husband wanted to withdraw life support because he didn't believe that that was her idea of quality of life. her parents, for religious reasons, were very opposed to the withdrawal of life support. So sadly, these three very well-intentioned people battled their way all the way up to the Supreme Court of the United States, which, if you're getting to the Supreme Courts, the United States level of our legal system, you have spent a lot of money and time on lawyers, which, let's just be honest, spending time and money with lawyers is not fun and is avoidable, which is nice. And sadly, when you get to the courts, the one thing the court system doesn't provide is an apology or a validation. It's just going to make a decision, and everybody is going to be left with following that decision. So for Terry Schiavo, they did have a college roommate of hers who came out of the woodwork and testified under oath that when they were younger at a bar, Terry had made a statement that she didn't feel like being on life support when you're in a permanent vegetative state was quality of life. So based on that roommate's testimony, the Supreme Court of the United States allowed the life support to be withdrawn. And then the husband had her body cremated, which her parents preferred that her body be buried. And I believe to this day, they still don't know where the cremains are. So it's just a really sad situation all the way around when you have very well-intentioned people who have different philosophical point of views. So having a medical directive is, in my opinion, the most loving document in your estate plan, because part of what you do in a medical directive, in addition to picking the people that you want to be your medical advocate, to be at your side and making those decisions after consulting with the doctor about your specific medical situation, I do ask clients in these documents to make decisions about life support, their burial preference, and their organ donation preference, because most of us in polite society don't sit around the table and talk to our kids about whether we want to be buried or cremated, or what our ideas are about organ donation. I know from doing estate planning for 20 years, I have plenty of clients that are willing to be organ donors. I have lots of clients that don't want to be organ donors, and I have just as many clients that are willing to donate their body into science, to medical research, and to even be a cadaver. So medical research has really expanded. Our medical technology and knowledge is amazing. So what they can do now with, stem cells and organ donation, donating your skin to burn victims, there's so many different uses of a body that it's really important, in my opinion, for people to make those decisions themselves, because it really truly does ease a burden from your loved ones during an already difficult time. So basically what we've talked about are your durable powers of attorney. I'm going to talk in just a moment about wills and trusts, but before I segue out of this topic, I do want to let you know that the state of California so wants you to have a medical directive that you don't have to work with an attorney to do one. In fact, you don't have to work with an attorney to do an estate plan in general, but people don't know that oftentimes their medical insurance companies have free medical forms that if you call your insurance company, I think oftentimes you'll call the business office. If you ask if they have either a statutory medical directive or their own form of a medical directive, oftentimes people are surprised to find out that their medical insurance companies has these forms, and all you have to do is fill it out and then just make sure that you're properly signing it. So if you are signing your name before a notary, that's sufficient as far as executing that document and having it be legally binding. Or you can have two separate people witness you signing your signature if you don't have the ability to have a notary sign and notarize the document. But it's important to note that if you're going to have two people witness your signature and not use a notary, California has a requirement that those two witnesses have to be disinterested. Being a disinterested witness is somebody who doesn't have an interest in the person's financials and a person who's not named on the document. So if I named my sister to be one of my medical agents, I should not have my sister witness my signature as one of my signature witnesses. So neighbors make great witnesses. So if you wanted to take my advice and call your medical insurance and get this form and complete it yourself, taking the form next door to your neighbors and asking them to be the two witnesses is a good idea, because usually your neighbors aren't related to you and they're not on the document. I know that Kaiser, Sharp, Scripps, those three insurance companies, and UCSD, how can I leave UCSD out? They all have their own medical directive. If any of you on this presentation have the ARAG legal insurance plan, ARAG is a legal insurance, which is a form of insurance that large corporations will oftentimes offer to their employees as an employee benefit. I know that at UCSD, the open enrollment period for ARAG becomes available in November. So for those of you who have the ARAG legal insurance plan, I would encourage you to use it because you can actually go through your insurance and have an attorney prepare these documents so that you don't have to do them yourself. There's a lot of really good attorneys that are part of that ARAG legal insurance plan. We're part of it. I know a lot of good estate planning firms in San Diego are also part of it. ARAG Insurance is a really good legal insurance. It's a really good company. We've had a really great experience with them. So I just wanted to mention, for those of you who have that benefit, if you haven't utilized it, I would encourage you to do so. I know that they offer full coverage or partial coverage, so I would encourage you to call ARAG to verify what coverage you have. If you have full coverage, that means your estate planning documents are fully covered by your legal insurance. If you have partial coverage, then you do pay out of pocket for a portion of the fee of those estate planning documents. ARAG used to include notary fees. They no longer include that. So that is something that a client would pay out of pocket, or you can see if maybe your bank might notarize complimentary, as some banks do. AAA Premier members can get a few notary signatures complimentary as being a AAA Premier member. And then ARAG covers part of the deed fee to transfer your house into your trust, but not all of it. So when you have ARAG, there are a few nominal costs, but out of pocket, for the notary, it's anywhere from $75 to $150. And for the deed fee, it can be anywhere from $90 to $600, just depending. So if you have that insurance, I would encourage you to utilize it. For those of you who have adult children, I believe that some ARAG plans cover estate planning for adult children that are under the age of 25, I think. But I think you have to declare them as a dependent for the insurance to cover them. I understand that many 19, 18, 21-year-olds probably don't need a trust, but they do need to have their durable powers of attorney in place. So for those of you who have your estate plans in place, if you have the family coverage and if you have a dependent child who's an adult, I would encourage you to have them call ARAG and to use your insurance to get their medical directive and their durable power of attorney in place, because those are two very important legal documents. So I've covered the durable powers of attorney, I think, pretty thoroughly. So I'm going to transition now into talking about wills and trusts, because that's where the heart and soul of estate planning truly lies. And unfortunately, there is a lot of misinformation out there about that. So people will ask me, what happens if I die without having a will or a trust? And in the state of California, we have a law called an intestate statute. What an intestate statute is it is a law that basically determines who the rightful beneficiaries are to inherit your estate for assets that are titled in your name that don't have a pay on death beneficiary tied to it. And what I mean by that is, if I'm a single person and if I have a retirement account that names my sister as my pay on death beneficiary, but if I have a checking account that doesn't have a beneficiary attached to it, then if I died without a will or a trust, the retirement account will pay directly to my sister if she survives me, because she's listed as a pay on death beneficiary. So those assets pay directly from the financial institution to the beneficiary. But assets that are in my name that don't have a beneficiary attached to them, that's where the intestate statute will decide who the rightful beneficiaries are. And the way that statute works is it goes through a hierarchy of your bloodline. So if I'm a single person, the intestate statute is first going to give my estate to my biological and legally adopted children. So if I have two living children as a single individual, they would inherit my estate 50-50. If I have two children, but one of them predeceased me, but has two children of their own, the intestate statute would still divide my estate equally, giving my surviving child 50% of my estate, in giving the surviving children of my deceased child the other 50% of my estate. So if I died as a single person but had no living lineal issue, then the intestate statute would give my estate to my mom and dad or to my surviving parent. And if both of my parents passed, my estate would then go sideways bloodline to my brothers and sisters. And if any of my brothers and sisters have passed, if they have children of their own, my nieces and nephews, then the deceased sibling share would go down their lineal line to my nieces, nephews, great nieces, great nephews. And if we still haven't found a living beneficiary, we go up to the grandparent level, then to the aunts and uncle level, then to first cousin, second cousin, third cousin. And if we still don't find a living blood relative, then the final beneficiary is going to be the state of California, which in my 20 years of practicing estate planning, I have never seen an estate escheat to the state of California because there's always been a surviving blood relative found. And there's companies now that do that for a business where you pay them a fee and they go through and they find that closest living biological blood relative. So if you passed away in California without a will or a trust, the intestate statute decides who inherits. If you have a will, what a will does is and this is a testamentary will, a will is going to identify a person who's called an executor. An executor is the person who you are entrusting to deal with the final estate administration of your estate after you die. And what that means is if I have a will and if I name my sister to be my executor, if she accepts that nomination, because she is just nominated, she's not obligated to do that job until she accepts it, then her job would be to notify my beneficiaries that I've died because they have a right to notice. She also has to mail my beneficiaries a copy of the will because under California law, all beneficiaries that are named in a will have a right to read the will. And if I have a closest living biological relative who's not named in the will, but is deemed one of my closest living biological relatives, they are also entitled to that legal notice. And what I mean by that is if I have 3 siblings and no husband, no kids, but I give my estate to 2 of my siblings and not to a 3rd sibling, because that 3rd sibling under the intestate statute would be my closest living biological relative, they are also entitled to legal notice of my death because of their hierarchy of being my closest living blood relative, even though the 2 siblings that are named in my will would be the rightful beneficiaries of those assets. So when you create a will, you're identifying who the person is who's going to be the executor. That's the person that's going to notify the beneficiaries of your death, send them a copy of the will. With the notice to beneficiaries, that opens and closes a statute of limitations for beneficiaries to contest. They also have to pay all of your final bills because legally nobody can inherit from your estate until all your final debts, creditors, taxes have all been paid. All creditors and debts have to be closed, paid in full. And then from whatever monies remain, the beneficiaries are entitled to those assets. But before the assets are distributed, an executor prepares a document called an accounting. The purpose of the accounting is to show transparency from the executor to the beneficiaries as to what assets were in the estate when the person died, what assets have come into the estate after the person died, and what bills and debts has the estate paid on the decedent's behalf. Then the accounting is going to show the net estate and show what each beneficiary's anticipated distribution is. If a beneficiary has any questions about the accounting, or if they feel that the executor has mismanaged any of their duties, they can then take that executor into court, and judges take all of this very seriously. So assuming that there are no objections, the executor would then make distributions. Once all the assets have been taken out of the decedent's name and titled into the beneficiary's name, that is when the executor's duty is completed. And there's a very similar process that works when you have a trust. But one really important thing that I want you to listen to is in California, having a will does not keep you out of probate, and having a trust also does not keep you out of probate. So in California, there are 2 things that will take estates into the probate court process. One is if you own real property and if it's not titled in your trust when you die, that will trigger probate. So going back to a will, if I'm a single person and if I own a house and if I have a will that says that I give my sister my house and I give my sister everything inside of my house and I give my sister all of my assets, when I die, even though I have a will, my estate will have to go through a court process called probate because I own real property that's not titled in a trust. And that's why so many people in California have trusts. It's because they're homeowners. So when you own real property in California, even if you have a will, your estate will go through probate because the fact that you own real property that's not titled in a trust when you die will trigger that court process, which means that asset cannot be sold. That asset cannot legally be inherited until a court process called a probate has been started and open. So the other thing I want to mention is that the other thing that takes us into court is, let's say that I have a house that's titled in a trust, which means the house won't trigger probate. But if I have 3 bank accounts, and if 2 of my accounts are titled in the name of my trust, but if 1 bank account is titled in my own name, and if I don't have a beneficiary tied to that account, so I die with an account in my own name that doesn't have any beneficiary tied to it, if the value of that asset plus any other asset titled in my name that doesn't have a beneficiary tied to it, if the aggregate value of all of those assets added together exceeds $166,250, then those assets will trigger probate. So I mention that because I get calls all the time, and I understand where people will call and say, Heidi, I have a will, and I just want to make sure that when I die, there's no probate. So my first question is always, do you own a house? And if their answer is yes, then I have to explain to them that having a will when you own a house will not avoid probate. It triggers probate. And so because of that, they actually need to create a trust, and we need to do a deed that moves the house into the name of the trust, because that's how that asset will avoid going through probate. And then clients will call and I'll ask them, do you own a house? Because they just have a will. They'll say no. And I say, okay, so tell me about your financial situation. Do you have assets in your name that exceed $166,250? And oftentimes the answer to that is yes. So then the question is, how old are your beneficiaries? So I have 2 kids that are minors. So if I can't have my kids on my checking accounts, well, I mean, I can, but if I died yesterday and if my kids are minors, then those accounts are going to have to be under the watch of a custodian until the kids turn 18. So if your net estate is over $166,250, and if you have beneficiaries that are minors, or if you have beneficiaries that you want to have some contingencies in place as to having them inherit assets at a later age versus at the age of 18, then it's also prudent to consider creating a trust and having those liquid assets in a trust. One reason is, when you create a trust, one of the benefits of a trust, one of the many benefits of a trust, is you do pick a person who's called a successor trustee. They basically do a similar job as an executor does under a will, except a trustee is in charge of managing those assets that are titled in the trust and that name the trust as the pay on death beneficiary. So if my husband and I died yesterday and we have our 2 kids that are both minors, we have language in our trust that allows our trustee to use monies from our trust to pay our children's guardian, so that while our children are being raised by their legal guardian, it's our assets that will be used to pay for their health, education, maintenance, and support. So our guardian's not paying out of their pocket to raise our children. And then once our children are 18, which is the legal age of adulthood in California, that's when the conversation shifts, so that the kids will then have a conversation with the trustee, and the kids can start asking for distributions from the trust for their health, education, maintenance, and support. Now, mind you, when you pick a trustee, you want to pick somebody who's like-minded, who has similar morals, financial morals as you do, because if you're the kind of parent that when your child turns 16, you would buy them a used Honda Civic, you probably don't want to put a trustee in place that would use the life insurance money to buy that child a Porsche Boxster. So picking a trustee is a really important decision, because you want to pick somebody that will treat your beneficiaries fairly. You want to pick a trustee that's going to treat those beneficiaries impartially. You're going to want to pick a trustee that is good with financial affairs, because that is their job, is to manage your financial affairs, to diversify those finances. And then they have a lot of subjectivity as far as when to give monies to the kids and for what purpose. So when you're a trustee, you have the ability to say no. So if I were a trustee and if a beneficiary hypothetically asked me for funds to pay for their college tuition, but if on their last report card I saw that they had an F grade point average, I would tell that beneficiary that I'm not going to use trust funds any longer to pay for their tuition until they bring their GPA up. So when you're a trustee, you are the gatekeeper of these monies. So when it comes to picking trustees, if you have younger children or if there's younger beneficiaries, whether they're nieces or nephews or whatever the legal relationship is, you want to pick like-minded people because they do have a lot of subjective discretion through these documents, which is a good thing. But when you do a will, because wills are subject to going through probate, and sometimes not, if you have younger beneficiaries, those assets are put into an account that's overseen by the court. And under California law, when you don't have a trust, those assets can be released to that beneficiary once they turn age 18. So sometimes when people call me and they don't own real property, don't plan on owning real property, but they have younger beneficiaries, whether they're their children, grandchildren, nieces, nephews, or neighbors' kids, that's my next question is, do we need to put age contingencies in place? Because one big nuance between a will and a trust is with a trust, you can put a lot of nuances in place that with a will, you just can't, because the courts don't have the time to be overseeing all of that. So they don't. Once a beneficiary is age 18, they get all the money. I can put language in a trust that gives the trustee permission to drug test a beneficiary and to postpone a distribution should a beneficiary test positive for illegal drugs. In a will, you can't put language like that because the courts just don't have the ability or desire to enforce it. I also ask clients when we do their estate plan if they want to include language that if a beneficiary is married at the time of acceptance, would they want to make sure that that beneficiary keeps those inherited assets titled in their own separate name, which retains that separate property status. The benefit of that is in California, if I inherited and if I took that inheritance and kept it in my own separate account, if my husband had creditor liability or was in an accident, then his creditors can come after all of our joint assets, but my separate property assets are protected from his creditors. And if we were to get a divorce, any separate property assets that you keep in your own separate name are not part of a divorce. But what often happens in California, because we have these complicated quirky community property laws, is people inherit, they put the check into a joint account because that's the only account they have. And unbeknownst to them, they just transmuted what was a separate property asset into a community property asset. So you can put contingencies in place that requires beneficiaries to keep assets separate property to keep that separate property status, but you can only do that through a trust. So there's a question in the chat that I'm going to pull up real quickly. It says, I've heard that someone like an adult child can be a co-trustee for a trust. Is a co-trustee better, worse than a financial DPA? Can there be more than one co-trustee? Okay, that's a great question. So when you create an estate plan, you have 3 financial documents in your estate plan. The trust, durable power of attorney for financial affairs, and will are your 3 financial documents. So you have the same people named in the same order in all 3 documents. So if I named my sister to be my trustee, I'm also going to name my sister to be my durable power of attorney for financial affairs, because if I were hit by a drunk driver, the trustee puts her in charge of assets that are in my trust, whereas the durable power of attorney gives her access over my financial assets that are not titled in trust. So you want your trustee to be on both the trust and the durable power of attorney so that they have full financial powers over all of your assets, regardless of how those assets are titled. And then you also name them as an executor so that if there's an asset like a car, for example, that's not titled in trust, which cars usually aren't titled in a trust, that pour over will directs the executor to put the car into the trust and to distribute those assets to the beneficiaries of the trust. So for all of those reasons, your trustee is going to be the same person as your durable power of attorney, who's going to be the same person as the executor. So you want those nominations throughout those financial documents to be the same. So if you have a co-trustee, you're also going to have a co-durable power of attorney, and you're also going to have a co-executor. So whether or not it makes sense to put people in that co-relationship truly depends on your specific situation. It depends on how well those 2 people know each other. It depends on how well those 2 people will communicate and work effectively together. Sometimes co-trustees make a lot of sense. Sometimes they're disastrous. So it really just depends on who the people you're thinking about. I know sometimes people tell me that they're thinking about doing a co-trustee because they want to check and balance. And with all due respect, my answer to that is you're probably picking the wrong people, because when you put a trustee in place, for lack of a better word, the word trust is in the word trustee. They are under a fiduciary duty under California law. So if any beneficiary took a trustee into the courts, judges and courts take that job very seriously. And if a judge were to deem that a trustee made a mistake, even an honest mistake, that individual trustee will be made to pay out of pocket to reimburse those beneficiaries for anything that the judge finds wrong. So when a person does agree to be a durable power of attorney or a trustee or executor, it is really important to go get legal advice from a professional, because once you agree and accept that position, California imputes on you the same knowledge that I have after going through law school, passing the bar, and doing estate planning for 20 years. So there are specific processes involved when a person dies and an estate is being administered, whether it's an estate with a will or without a will, or an estate with a trust and or a will. So you always want to make sure that when you accept and agree to do those jobs, you understand the nature, scope, and duties that you're agreeing to do, because California just imputes and expects you to go get that advice. But luckily, within these documents, there is language that allows the trustee to use trust funds to go hire whatever professionals they need to help them in the administration of the trust. So if you were to hire an estate planning attorney to guide you through the process, the assets in the trust would pay that attorney's fee. You don't pay it out of your own pocket. Just like after a person passes away, they often have to have a final state and federal income tax return filed. And that is something that the trust assets would also be used to pay. So that's a great question. So the next question is, are there any disadvantages with having somebody as your trustee who lives outside of the state of California? So I will tell you my answer to that. I don't see any problem with it. Luckily, in 2022, with Zoom being used the way it is so much easier now to have out-of-state people acting, because between computers, PDFs, fax is not so much, but Zoom technology and passwords and logging in, it's so much easier now to be able to remotely access and manage a person's assets from afar. I don't have any problem if your trustee is in state, out of state, in county, out of county. But one important thing to mention, and I don't make this rule, so I know sometimes when I mention this, people are kind of discouraged, but it's not my law. But the United States does have a bias where they want your trustee to be a US citizen or a US resident. And the reason for that bias, it is a logical one. It's for jurisdictional purposes. So if my sister became incapacitated, and if I lived in Canada hypothetically, and if I came into the United States as her trustee and started managing her assets, but then basically took all those assets and ran out of the country, if I were a US citizen or US resident, then the United States could use the extradition process very easily and quickly to pull me back into the States, and then I would have to go to court and pay the beneficiaries back. But if I'm not a US resident or citizen, then it's not as easy to find a remedy for the beneficiaries. And the IRS reserves the right to tax a trust as what's called a foreign trust. So there's a lot of different reasons why there's a bias in the United States to have your trustee be a US resident or citizen. If you did have loved ones outside of the country that you wanted to put in these roles that aren't US residents or citizens, the way to kind of cure that problem is to put them as a co-trustee with somebody who is a US resident or citizen. So there are ways of having non-resident and citizens acting in that role and not causing or tripping into those potential problems. So I think I've done a pretty good job of explaining the difference between a will and a trust, but just a quick recap. For lack of a better metaphor, when you think of a trust, I like to describe it as a bucket. So when you go in to do an estate plan, basically what you're doing in that planning meeting is you're deciding on the size, shape, and color of your bucket. And then once that trust is signed and notarized, that's when the trust legally exists. And that's when you get to the second step of estate planning, which is the process of moving your assets into the bucket. Because in California, if I have an empty bucket and if I own a house, which means if I have a trust, but my house is not titled to my trust and I die, that house will trigger probate even though I have a trust. And I can tell you from personal experience, my grandfather, who used to live in Sun City with his wife, hired an attorney in Riverside. And about 30 years ago, he paid about $5,500 for an estate plan, which 30 years ago, that was a lot of money for an estate plan. Even today, I don't know very many firms that charge that much money for an estate plan. So even by today's prices, that's a lot of money. So when I became an estate planning attorney and kind of figured all this stuff out, I went ahead and I pulled his deed because I wanted to make sure that his house was in his trust. And to my surprise, it wasn't. So I remember sending my dad an email saying, Dad, I thought that Grandpa went to this attorney and did a trust and da 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 da. My dad's like, yeah, he paid this guy a ton of money, which he did a ton of money, unfortunately. And apparently the attorney just never did the deed to transfer the house into the trust. So when there's bad jokes and funny jokes about lawyers and how unethical they are, it's lawyers like that those jokes are being told about, because when you create a trust, if your attorney's not giving you the option to also retain the attorney to prepare the deed that puts the house into the trust, having an empty trust in California is honestly pointless, because now the estate's going to go through probate. And one of the benefits of doing the trust is to avoid that probate process. One of the other problems with probate, aside from it being a slow public process, is the fees are statutory, which is a fancy legal way of saying they're predetermined by law. So when you have an estate go through our probate court, the fee is not determined by the judge or the attorney. It is determined by the statutory fee calculation. So on average, most probate fees that we've handled have ranged anywhere from $7,000 to $25,000 to $50,000, which is a lot of money considering most estate plans are anywhere from $1,500 to $2,500 to $3,500. So if you have an estate plan, not only do you get to make all those decisions, but you're also avoiding these court processes and you're saving your loved ones a lot of money and keeping everything private versus public. So that's also a reason why people want to avoid probate, is the probate fees are excessive. Somebody just posted a question about, can your attorney be your trustee? I personally think it's a conflict of interest for your attorney to be the acting trustee, because I can tell you honestly, I spend pretty much every day in my office meeting with clients, drafting estate plans, updating estate plans. And if I'm not doing that, I'm appearing in court on behalf of my probate and conservatorship clients. So I don't think an attorney makes necessarily the best trustee, because most attorneys are tied to their desks. One of the things a trustee has to do is they have to go to the house and meet with the realtor and have the house listed for sale. And they have to go through the personal contents of the house. And most trustees aren't going to know who's going to want mom's wedding ring and who's going to want the couch, and which things in the kitchen are family heirlooms are valuable and which things are not. But you know who knows all that is family. So I personally think that I know that there's a few estate planning attorneys in San Diego that want to be your trustee. I am of a different opinion. I'm happy to be the attorney representing the trustee, but I don't want to be the trustee because frankly, I don't have the time to go meet with a realtor and list a house for sale and to go to the bank and get the death certificate and do all that. Because being a trustee requires a lot of footwork. And yes, you could have your attorney be your trustee, but I find that usually hiring the attorney means that you're actually hiring the secretary or the paralegal, and they're doing all the work and the attorney isn't doing very much of it. But yet you're paying a premium because attorneys can charge a percentage of the estate as trustee compensation. That's why sometimes attorneys want to be your trustee, because I know that I referred a client to a private fiduciary and she took a similar fee structure as an attorney. She took 1%. And to administer the estate of one of our wealthier clients, she got paid $77,000 in trustee compensation based on the calculation. She hired us to represent her in her capacity as the trustee, and we charged a flat fee of $2,800. So there's a big difference between what we charge being the attorney representing the trustee, and ironically, we end up doing all the legal work. So the legal side of it is really only about a $2,800 to maybe $3,500 fee structure process. But being a trustee under California law, most trusts are written where the trustee is entitled to reasonable compensation. And under California law, reasonable compensation is deemed to be 1% of the net value of assets that are titled in trust. So with real property in San Diego County being as valuable as it is, plus your liquid assets, that 1% fee can be as high as $77,000, but yet the person being the trustee might only put 10 hours of time in. So yes, your attorney can be a trustee. There's also also corporate trustees. All banks and financial institutions now have trust departments in-house. So if you are a proponent of, I don't know, Vanguard, and think that Vanguard and all of their stuff is amazing, I guarantee Vanguard has their own internal trust department. So you might consider having Vanguard be a corporate trustee for you if that's where your comfort level is as far as financial management. My only hesitation with a corporate trustee is I'm not opposed to a corporate trustee charging their 1% like a regular person can charge. In fact, it makes more sense for a corporate trustee to charge that 1% because they know what they're doing and they're going to do it correctly. So why not pay a professional than pay a layperson who doesn't necessarily know the process and they have to hire an attorney to help them through that process. But if you have younger beneficiaries, one problem with a corporate trustee, and I understand the reason, corporate trustees don't ever want to exercise discretion because under our trust administration law, that's the gray area and that's where they can be sued. So if a corporate trustee is towing the line and telling a beneficiary who's failing college, I'm going to turn off this tuition payment and bring up your GPA, that beneficiary can take the corporate trustee into court, as all beneficiaries can. So for those reasons, anytime I've had clients that hire corporate trustees that review our trust, the number one thing that the corporate trustee does with the big red pen is they get rid of every single clause in my trust that requires discretion. So if you have younger kids and want to give your trustee discretion to pay for their health, education, maintenance, and support, corporate trustee pretty much is only going to pay for like medical expenses and educational expenses, whether a benefit thing that a corporate trustee is going to do is they're not going to enforce a drug provision because they don't want to exercise that discretion or be sued for not exercising the discretion. So if you've got younger beneficiaries or a family dynamic where you need a trustee that's going to roll up their sleeves and need to exercise discretion, then a corporate trustee is probably not the right trustee for you. In which case there are private fiduciaries out there. Private fiduciaries are professional trustees, but they're individuals. They're not corporate backed by a corporation. If you're working with a private fiduciary, it is nice if you can find a private fiduciary who's part of a company so that there's a backup system in case if something happens to that individual, that there's other people that are in an office that can pick up the file and take things over if that private fiduciary was also in the same accident as a drunk driver, hypothetically. So when you pick a trustee, if you have the ability to pick family or friends, they're always my first choice because they know you. They are going to have a much easier time going through the house and distributing assets to your family and friends because they know who each other are. But sometimes in relationships, it's not a good idea to have that trustee be family. And it's better to have that trustee be a third neutral, unbiased party. So that's why when you do an estate plan, part of what you're doing at the beginning of the process is you are having a planning meeting with an attorney to kind of walk you through all these different questions and talk through all the different scenarios, talk about your specific family situation and dynamic, because for every 5 people that might name family to be a trustee, and that's a good choice, there's probably 10 other people where naming family is not a good choice. And sometimes when people put the wrong people at the helm of these documents, that is where an estate plan implodes. And that's where some of these stories come from that you hear about, because pretty much every other client that comes through my door is like, oh, I've got a story for you. And they're usually the same. It's the wrong trustee making very bad decisions, or it's the entitled failure to launch relative who takes the money and isn't being transparent and it isn't communicating, or it's the daughter who hates the brother who feels she's entitled, so she puts the house in her name and doesn't even give the brother a fair shake at whether or not he wants the house to be part of his share. So there's a lot of emotion in estate planning. There's a lot of dynamic in estate planning, but when you have an estate plan, it is such a gift to your family and friends, because when you make these decisions while you have capacity, the courts give these documents deference. So putting the right people in the right roles, identifying who you want your beneficiaries to be, putting in any clauses that you think would be helpful for ages of distribution, separate property clauses. I ask about animals as well. I'm a big animal person, and the one thing I don't want to have happen to my pets is for them to be euthanized. unnecessarily because there's not language in my trust that gives my trustee permission to place them with my family friends or to give them to a no-kill animal shelter. So estate planning does a lot more than just identify who gets what. It keeps you out of the conservatorship process if you lose capacity. It keeps your estate out of probate as long as your assets are titled correctly. You get to pick the people that are the best people to make those financial medical decisions. You get to choose who your beneficiaries are. But when you do an estate plan, it really is a two-step process. The first step is the process of doing the planning meeting, drafting the documents, signing and notarizing the documents, and putting those documents in place. The second part of the process is changing title of your assets because you have to fill that bucket with those assets to avoid probate. So one thing I want to mention for those of you who have existing estate plans is 15, 20 years ago, when I first started practicing law, I used to tell my married clients to name spouse as their first beneficiary on all tax deferred assets, 403Bs, IRAs, 401Ks, simple Roths, and to name the trust as the secondary beneficiary. But those laws have changed dramatically. So now in 2022, you don't want a trust coming on as a beneficiary of a retirement account because that can trigger an unnecessary taxable event to the beneficiaries that are named in the trust. So if any of you have estate plans that have been around for a while, I would encourage you to contact the financial institution that holds your retirement accounts and to review your beneficiaries, because if your trust is on there as a beneficiary, you want to change that beneficiary to be people named individually by name. So whether that's 3 people, a third, or 2 people, 80%, 20%. The nice thing about your retirement accounts is you can change those beneficiaries through filling out a change of beneficiary form directly with the financial institution. I know UCSD has all of that online, so it's super easy. And for those of you who have retirement accounts, if you haven't reviewed your beneficiaries in a while, I would also encourage you to do that, because sometimes when we create these retirement accounts, maybe one of the kids are born, but not all 3 of the kids. So just know that those assets are going to pay to whoever those beneficiaries are. So if you have 3 kids at the time of your death, but only one of those kids is named as a beneficiary, it's only that one child who's named as a beneficiary who will inherit. So making sure that you have an estate plan is prudent. The other advice I give to clients is I give them what I call homework, which is basically a step-by-step process. I can put real property into a trust. I can create a document that puts all their tangible personal property into the trust, but clients have to deal with their banks because obviously a bank isn't going to let me change title of somebody else's bank account for good reason. So I give clients homework that explains how to put their investment accounts into trust. Basically, the way that you avoid probate in California and how your assets should be titled is you want all real property titled in a trust, including timeshares. If any of you have real property that was in your trust, and if you've refinanced your house lately to take advantage of these amazingly low mortgage interest rates, sometimes mortgage companies will take the house out of the trust for the refi. So you got to make sure that the house closed title with the house going back into the trust at the close of the refi. That doesn't always happen depending upon how you fill out the paperwork. And for liability reasons, mortgage companies will take the house out of the trust, but they don't always like friendly remind you that you need to put the trust back in the paperwork to have it go back into the trust. So if any of you have refinanced your house, I would encourage you to check the title to your deed, because there is a possibility that the house might no longer be in the trust, in which case, if you don't fix that and if you pass away, even if your trust is current, if that real property is not titled in a trust, that will trigger probate. So when you create an estate plan, you want to make sure that the real property is in trust, the timeshares are in trust. If you refinance, that the house goes back into the trust at the close of refi. And you want to make sure that all of your taxable investment accounts are either titled in the name of the trust or name the trust as the pay on death beneficiary. So taxable investment accounts include bank accounts, checking accounts, money market accounts, CD accounts, and you can either title those accounts so that they're titled in the name of the trust, or you can name the trust as a pay on death beneficiary so that when you die, those accounts pay directly to the trust. Life insurance should name the trust as the beneficiary. If you're a business owner, your stock certificate should be titled to you as trustee of your trust. If you own an LLC, your membership agreement needs to be titled to you as trustee of your trust. Only retirement accounts and annuities don't name the trust as a beneficiary for tax reasons. So any tax deferred asset, retirement account, 403B, IRA, 401k, simple Roth, those assets should name individuals as beneficiaries, and you always want to make sure you have a primary and a secondary, because the key to avoiding probate with those assets is by having a living beneficiary alive at the time of your death to inherit that asset. So before we close, because I think we're done at 1 o'clock, Suzanne had wanted me to talk with you about digital assets. So one new change in the law is when we're writing estate plans now, we are included language in your durable power of attorney, will, and the trust about digital assets. So if I were to become incapacitated, my loved one who's named in these documents would have the ability to access my computer. They would have the ability to go to my bank and to be given my passwords. So digital assets is a new area of the law that these powers, if you have an older estate plan, you might consider updating your estate plan to include this digital power language, because if your estate plan doesn't have this language, it's almost impossible for you to have access to social media, computers, passwords, and financial institutions are very reluctant to give that information out for liability reasons. So one of the other things that I give clients in their estate planning binder is I do have a place for them to put their logins and passwords and their bill pay information, so that if a person were to become incapacitated, by having all that financial bill pay login password information in the estate planning binder, it makes that transition a lot easier. But that is something that I do encourage clients to revisit on an annual basis. I have it as a reoccurring event on my calendar to remind me as well to go through my financial information to make sure that all my accounts in my estate planning binder that I've listed are current, that my logins are current, my passwords are current, and my bill pay information is current. Because one of the hardest things for a loved one to do when they have to make the decision to step in and take over the management of your assets or to administer your trust after you die is they don't know what assets you have. So absent the old-fashioned way of going through file cabinets and drawers, so much of what we do is online, that having that information memorialized, whether you keep it in your estate planning binder or whether you have it on a flash drive in a safe deposit box so it's in a secure location, you just want to make sure that your loved one knows where that information is, so that when the time comes for them to access it, they can. All right, well, I think we just had 1 hour today for this educational presentation on estate planning. I do apologize, I talk very quickly. It's just there's so much information that I like to go through with all of you about estate planning. It's so important. I find it fascinating. I hope you found this presentation informative. For those of you who don't have an estate plan, hopefully this was very helpful to understanding what an estate plan does. For those of you with an existing estate plan, make sure that you're staying on top of reviewing your estate plan and keeping it current. I mean, unless you have a change to your trustees or beneficiaries, most estate plans are good for about 8 to 10 years. So when you see those attorneys on TV advertising that they're going to find something wrong with your estate plan, people that advertise using fear tactics are usually the attorneys and professionals you want to avoid. These documents and these laws don't change that often, but they do change often enough that 8 to 10 years is generally a good rule of thumb. For those of you who have ARAG legal insurance, you get estate planning time every single year. So I have some clients with ARAG that come and see me every year, whether they want to make changes or not, because they know that they can come see me. And whether it's a 5-minute meeting with 2 questions or whether it's a full hour meeting with a lot of questions, it's covered by their insurance plan. So for anybody who doesn't have the ARAG legal insurance, if you want to look into open enrollment, I think you can call the benefits office there at UCSD and they can probably tell you some more information about it. We've had a really good experience working with the ARAG legal insurance company. It's a very respectable insurance company, and it really is, out of all the different legal insurance policies that our office accepts, it truly is by far one of the best ones. So thank you guys so much for your time. Thank you for your nice comments. As I said, if anybody didn't get my estate planning handout, please feel free. My phone number and my email is in the chat. I am more than happy to email a handout to you. The handout is basically about estate planning, and it breaks all the different documents down and explaining what each document does. So, all right, have a wonderful rest of your day. Thank you so much for your time, and talk to you guys later. Bye.
Thank you so much, Heidi. That was great.
Thank you.